I'm very grateful to Debra for underscoring the significance of the reporting regime, and more importantly, the fact that, and if I can make this as an opening statement, that notwithstanding the challenges arising from social distancing and the COVID-19 precautions generally, it does not in any way mean that enforcement or compliance is in any way relaxed, nor does it mean, for instance, that directors or officers, that their own fiduciary duties and obligations, particularly as it relates to risk awareness and risk prioritization, those themselves are also not relaxed. And it therefore means that the obligations are entirely those of the directors and officers of the principal financial companies and entities to do whatever is necessary to ensure compliance, while at the same time being very sensitive to the social distancing protocols and the fact that they are not able to adhere to all of the requirements, perhaps with as strictly as before. Happily for all of us, the principal regulatory agencies, and for those which are principally, perhaps I can describe them as the CBTT, the Central Bank of Trinidad and Tobago, the Trinidad and Tobago Securities and Exchange Commission, the Financial Intelligence Unit. If I treat with those as the principal financial regulators, on the 9th of April of this year, they issued a joint regulatory guidance on compliance with AML CFT verification requirements in light of COVID-19 measures. Now, this is fairly early on in COVID, but I think it was an extremely helpful document, and what it underscored is that while the guidelines remind all financial institutions to confirm and to continue providing essential financial services, they are in fact underscoring that the flexibility built into the existing risk-based approach for AML compliance continues, save that they are now putting the onus on the financial institutions to adapt or vary the adherence to the protocols, while still doing their best to maintain the overarching requirement, which is to ensure vigilance and compliance. What the guidelines and the guidelines themselves are, it's just about 4 pages, and it repays a careful reading. But I think if I can just make the point that the regulators are encouraging the risk-based approach as it relates to the various protocols, but they are in effect saying that directors and officers are required to perhaps reprioritize those risks and in tandem with the social distancing, and to ensure that these protocols are implemented in such a manner as to ensure the integrity of the financial sector. In other words, directors and officers are not permitted to delegate their responsibilities or to proceed on the basis that their responsibilities are in any way relaxed or perhaps removed, but in fact to be alive to these responsibilities, while at the same time managing the risks brought as a result of the COVID-19 social distancing protocols. It follows, therefore, and Debra is making this point, that the customary model where risk, as we appreciate, is a board-driven exercise, has even greater significance now. In other words, because risk, or the risk exposure, risk mitigation, risk management, and perhaps I should add to that risk prioritization, is in fact a board-driven exercise. It follows, therefore, that it is incumbent on responsible board directors and executive officers to relook at some of their protocols to see how, if at all, they can be, and I'll use the word relaxed, although it's not my first preference, but to relax them to enable the social distancing precautions and protocols to take place, while at the same time not in any way diminishing the significance of insurance that that these protocols are eventually met. Now, for many financial institutions, perhaps the most important, or one of the most important requirements is customer identity. In other words, to confirm using due diligence or appropriate due diligence that the person that you're dealing with remotely is in fact the person who is the appropriate person to deal with. In other words, customer identity. And that remains a key component of assessing, the money laundering, terrorism, and the proliferation financing risks. That's ML, TF, and PF. And what the regulators are reminding us is that they do require the companies to continue to verify documents as soon as the COVID-19 restrictions permit. So that where, for instance, customer identity has been provided in the form of perhaps copies of one's identification documents, it does not mean that as soon as the in-face or the in-person interviews permit that you don't confirm these things. They have also suggested that as an additional security feature, customers who are required to confirm who they are or their identity should also perhaps certify electronically that the document is a true copy of the original, or where necessary, that the photograph is a true likeness of my facial features or facial features of so-and-so. And that this certification is enforceable. It's a fairly good gambit, because it means that most professionals or reputable professionals will not certify something or someone unless they are fairly satisfied that that person is, or what they are certifying is true, accurate, or reliable. It also requires the financial entities to take reasonable measures to determine the authenticity of all government-issued identification documents. And all of that is in the context that, that criminal activities, particularly related to cybercrimes, are heightened because of the COVID-19 security precautions, which does not permit in-person conferencing or in-person due diligence. So if I can summarize what the regulatory guidance is on complying with AML, and of course AML means anti-money laundering, and CFT, that is counter-financing terrorism, verification requires, it would be firstly that do not let your guard down, that you are still bound by the very same fiduciary duties and obligations that are contained in the Companies Act and in the securities legislation. Secondly, that in relation to compliance, that while it is that until in-person conferences can be convened so that you can determine or you can verify the documents and the persons, that you should adopt all or every prudent financial method or collateral method, usually through certifications or perhaps by way of additional security features to confirm that they are the correct people that you are speaking to. If I can just offer a brief conclusion on 2 or 3 other matters arising, and Debra touched on some of these. The overarching point as it relates to really navigating the crisis, which really speaks to governance of private companies, would be really that directors and officers continue to be bound, and we are aware of Section 60 of the Companies Act, that which requires directors to oversee the business affairs of the company. That in no way is relaxed. And of course, Section 99(1) and 2 of the Companies Act makes it very clear that equally we have to scrutinize executive action as well as to maintain our fiduciary duties and obligations. I think for many directors and officers, one of the perhaps more challenging discussions that they would have had with their management teams is how do we go about looking after the best interest of the company, which is really the focus of the Section 99(1) and 2 requirements, because throughout, decision-making must always be in the best interest of the company. Now that does not, that's quite clear. It's not in the best interest of the government. It's not in the best interest of the shareholders. It's not even in the best interest of the directors. It is in the best interest of the company itself. And in making those decisions, which are very important decisions and perhaps long-lasting decisions, and the reach would be after the COVID-19 comes to an end, if it does, is to reconcile those decisions with the risks that is being faced by the company. And these risks, as we are aware, are not just related to financial matters. They often principally concern employees and maintenance of employees during a period when there are insufficient revenues to continue that. And the industrial court has gone on record in saying that there has been a heightened amount of not necessarily closures, but attempts by companies to reduce their holdings through fairly sophisticated language. For instance, we've heard about redundancies and retrenchment, but now there are things like temporary suspensions, and that's a term of art, not of law. It means that that a company that is intending to temporarily suspend the operations of a contract ought only to do that with the concurrence of the employee, because there is a contract of employment. And equally, if there are reductions in salaries or wages, or perhaps people are going off on vacations, on unpaid vacations, those things should always be after consultation, not necessarily even with the union, but with the individual employee, and should be manifested or evidenced by written documents. So the contracts of employment should perhaps be varied. There may be letters between the employer and the employee speaking to the changes, and that the parties agree, or that both parties agree to these variations. These are intended to reduce the likelihood of a loss of business continuity through strikes or suspensions or any other form of union activity. And it's of course not foolproof, but it does provide some room to maneuver, some wiggle room for a company to say, well, we did do our very best in looking after the best interests of the company to maintain our workforce, which required us to adopt very flexible working methods, and that the employee agreed with these approaches, and perhaps to expose the worker to legal advice, independent legal advice, so that the worker has the benefit of that in making a decision, which hopefully will also be supported by the company itself. I didn't want to go much further past that, Faye, but so with your permission, I'll be happy to stop at that point, and for you to continue from this point.